Welcome back to my channel. My name is Tammy. I am the owner of Tammy A1 Consulting, and we're going to break down or continue to break down the lawsuit against the Department of Education. I've done a few videos about this, breaking it down for you, the original complaint, the injunction that took place, and then also a joint status report that was released on the 17th of October. Now we have the final order, and that came in on the 23rd of October, and we're going to talk about that, okay? In order to get access to this document, all you have to do is just go to Google. You can type in American Federation of Teachers versus Department of Education, and we'll get you this document that's listed on Court Listener. So this is where you'll see just a transcript of everything that has happened from the time it was filed on the 18th of March, 2025, and everything that's happened with this case as it's been proceeding through the courts. One thing I want you guys to know, there's a lot of information that is out here. There's a lot of headlines when it comes to what the Trump administration is doing, what the Department of Education is doing. And one thing I want you guys to know is when you see these headlines and they're saying that, Trump has basically provided this favor, in a sense, to student loan borrowers, there is nothing when it comes to things that are congressionally mandated that the Trump administration is providing as a favor, in a sense, to student loan borrowers. These are things that they are legally supposed to do. And that is why we have this lawsuit against the Department of Education, because they were not doing these things. But we're going to go directly to the order. If you want to go back through the case, you can read more information about it, other status reports that were released throughout 2025. Also, when I mentioned the original joint status report that was released in October. It was actually on, I believe it was here on the 17th. You can read the actual agreement, what the Department of Education or what the American Federation of Teachers was asking the courts to enforce against the Department of Education or ordering them to do. And that's where we got this final order here that was released on the 23rd. And this is the document that we're going to go to. So basically you just click on main document or just hit download PDF and it will take you to the document that we are going to go over today. If you are someone that is currently enrolled in the SAVE plan, I know right now there are borrowers who are in the SAVE plan who may be like, I'm just going to ride this thing out, whatever the case may be. There's information in here that pertains to you if you are in the SAVE plan, okay? So here is, and it's only 5 pages of information, but it's a lot of information. And this is what the courts have agreed to, and that things that have been put in place for the Department of Education to do based off the agreement that was between them and the American Federation of Teachers back on the 17th of October. All right, so basically here we're going to get down to number 4, because this is where it gets into more or less what the Department of Education is ordered to do. So here's where it speaks about defendants, which is the Department of Education. The plaintiff is the American Federation of Teachers. Defendants will continue processing loan cancellations for borrowers who are eligible for cancellation under income-based repayment. So what that means, if you are someone who's eligible for income-based repayment and you have met the threshold under income-based repayment with your qualifying payments, the Department of Education is ordered to continue processing loan cancellation for you. Defendants will not deny as ineligible any borrower applying for the IBR plan on the ground that the borrower lacks a partial financial hardship as previously defined. They give you the section of the Higher Education Act. Defendants will hold such borrowers' applications in abeyance until defendants update their systems to allow for proper processing of the applications. Defendants affirming will state on the studentaid.gov that borrowers will apply for the IBR plan on or after July 4th, 2025, and were denied on the basis that they lacked a financial hardship are invited to reapply. So basically what this is that when it comes to student loan borrowers who qualify for income-based repayment, and the reason why they noted the statute is because it gives you the language that's connected to the income-based repayment regulations. And prior to the passing of the One Big Beautiful Bill Act, what was necessary in order for a borrower to be eligible for income-based repayment is that you had to have a partial financial hardship. Now, with the One Big Beautiful Bill Act, the passing of it, what that means is that now borrowers no longer need to have that partial financial hardship. But what was happening was student loan borrowers were putting in their applications for income-based repayment. They were being denied because they lacked a partial financial hardship. So what basically is being said is that the Department of Education, they still needed to update their systems, or that's what's actually supposed to be happening. That is why these borrowers were getting this rejection for the plan. So what they're doing is just saying that, hey, we know you got that rejection due to this partial financial hardship that should not exist. Basically, what you need to do is just reapply. So if you're someone who received that denial and you apply for the plan on or after the 4th of July, that is when the bill was implemented. The Big Beautiful Bill Act was implemented, was on the 4th. Just go ahead and reapply. That information should be on the student aid website, instructing borrowers to do so. Number 6, defendants will continue processing loan cancellation for borrowers who are eligible for cancellation under original income contingent repayment, pay as you earn, as long as these plans are in effect. So what that means is that if you are someone that is currently enrolled in income contingent repayment or pay as you earn, That means the Department of Education is going to go ahead and be processing discharges for those who have met the qualifying payments under these particular plans, these two plans, without you having to transfer into income-based repayment. So at first it was if you were enrolled in ICR, pay as you earn, or even save, they were not canceling loans. Even if you met the qualifying payments under those plans, you would need to transfer over into income-based repayment. Well, that's no longer a requirement. With this order, if you are enrolled in income contingent or pay as you earn, and you have met the qualifying payments, those 20 to 25 years, 240 or 300 qualifying repayments, then you are able to get your loans discharged. You do not have to transfer over into income-based repayment, okay? Defendants will continue processing application for PSLF buyback. So under number 7, we know that there's been an extreme backlog and a slow to processing when it comes to just everything in general with the Department of Education, but they speak about PSLF buyback. So those of you who qualify for public service loan forgiveness, that means that they are going to continue processing those applications, okay? How long it's going to take, we don't know. We'll be getting status reports coming up in the future. Defendants agree that for their internal purposes, the date a borrower becomes eligible to have their loans canceled under IBR, ICR, or pay plans constitutes the effective date of their loan discharge. So what that means is that the date that you meet the qualifying payment counts under these repayment plans, that is the effective date of your loan discharge. And the reason why this is important, they go on to speak more about it. The Department of Education is not going to file an IRS 1099-C for a borrower who becomes eligible for discharge in 2025 if the conditions in IRS Notice 2022-I are met. So basically what happens is there was a temporary provision, it was called the American Rescue Plan Act. And basically what that did was that for federal student loans that were discharged by the 31st of December 2025, those borrowers were not subjected to any type of tax bill. But of course, with the slow processing that's been happening with the Department of Education, the fear was that these loans that will be canceled, even though they were eligible because the borrower met the qualifying terms of the repayment plan in 2025, that if the loans were not canceled until sometime in 2026, that they will be set up to pay taxes, federal taxes on these student loans. So basically what this order is stating is that once you reach that qualifying payment count, as long as that's by the 31st of December, your loans are going to be effective for discharge the date that you meet the qualifying repayments under the plan, even if that means that the loans aren't technically discharged internally by the Department of Education until sometime in 2026. For avoidance of doubt, defendants agree that for their internal purposes, when a borrower has achieved eligibility under the SAVE plan, applies to transfer to one of the IBRs, original ICR or pay, on or before December 31st, and the application is approved on or after January 1st, 2026, the date the borrower becomes eligible for cancellation under the new plan constitutes the effective date of their loan discharge, even if that date falls on or before the date that the borrower's application was approved. So basically what this is saying, if you are someone that is currently enrolled in a SAVE plan, we have quite a few borrowers who are still enrolled in a SAVE plan. Under the SAVE plan, you are not required to make any payments currently, but the loans are accruing interest. What this is basically saying here is that if you are someone that's enrolled in a SAVE plan, and there are some borrowers who are enrolled in a SAVE plan who may have already made enough qualifying payments under a different repayment plan that will qualify them to get their student loans discharged. But what that means is that you would need to transfer out of the SAVE plan into one of those eligible plans. And what the department is saying, or under this order, what it's saying is that even if, because we know with the backlog of processing applications, even if your application isn't processed internally until sometime in 2026, doesn't matter. If you are in the SAVE plan and you transfer out of the SAVE plan into one of the other qualifying plans that qualifies you to get your student loans discharged in 2025, what they're saying is that they will cancel the loan. They will discharge the loan as long as you have that application in on or before the 31st of December. If you meet the requirements under ICR pay or income-based repayment, you've met those qualifying payments, those 240 or those 300 qualifying payments, they are going to discharge the loan as long as you get out of SAVE and put that application in on or before the 31st of December. Okay. All right, let's go down to page 3. And it says, pursuant to the above, defendants confirm that any borrower who qualifies to have their loans discharged through an income-driven repayment plan, which includes IBR, pay, and ICR, will continue to be reimbursed for any payments made on the loan after the final payment that qualified them for discharge. We have student loan borrowers who are currently that are in pay and ICR, who were at the time prior to this order and everything coming into play, their loans weren't being discharged, so they were continuing to make payments. You're continuing to make payments on your student loans because you don't want to go into default or deal with any of the madness. So what they're saying is that any payments that you have made in excess to what you are required to pay, the Department of Education will reimburse you for those payments, okay? Number 10, plaintiffs acknowledge that the IRS and the Department of Treasury and not the defendants have the final say on whether defendant's student loans cancellation qualify as taxable. Then they go into the Rescue Plan, American Rescue Plan Act of 2021. Here's where the Department of Education will file 6 status reports that provide public information about certain topics raised in this litigation. The first status report shall be 30 days after the current lapse in federal government appropriation ends. So we know right now there is a shutdown. Once that ends, this is when these reports are supposed to start back up, okay? They tell us in number 12, after the filing of the 6th status report, the parties will confer about the need for further reporting and if necessary, will inform the court of their positions on whether further reporting is necessary. Each status report will include, so this is when they tell us what each report needs to include. Information about the last full calendar month preceding the date of the report. Status reports due on November the 15th will provide information from October 1st to October 30th. So they tell us what these reports need to include. The number of IDR plan applications that were received, the number of IDR plan applications that were pending at the end of the preceding month, the number of IDR plan applications that were decided during the month, if possible. That number should be broken down by whether the application was approved or denied. The number of borrowers whose loans were discharged under an IDR plan during the preceding month, if possible. That number should be broken down whether the discharge was pursuant to IBR, ICR, or pay. It won't say save because the save plan is done. It's just, it needs that official knockdown out of queue, so to speak. The number of PSLF buyback applications that were received during the preceding month, the number of PSLF buyback applications that were pending at the end of the preceding month, the number of buyback applications that were decided, that is for which defendants have completed processing. So during the preceding month, broken down by the number that were approved versus denied. The number of borrowers whose loans were discharged under PSLF during the preceding month. In the department's report, the first status report, they shall explain the method that they use to identify borrowers whose loans are eligible for discharge through the IDR plans. They also will provide the number of borrowers whose applications for the IBR plan were denied on or after the 4th of July, 2025, on the ground that the borrower lacked partial financial hardship. So they want to know the number of people who were denied due to this system. I can't even call it error, but this update that the Department of Education didn't have in place. By agreeing to the foregoing, the defendants do not stipulate or to concede any factual or legal allegations that have been raised or could have been raised in this proceeding, including but not limited to any findings court would be required to make before granting injunctive relief. So this order was approved on the this is actually approved on the 25th, okay, of the 23rd of October. So this was all approved, and this is what the Department of Education has to this is what they are ordered to do. And this is where you have the actual official order here, where it shows that it is ordered here, and all of the information basically pertaining to that agreement, okay? But if you want to read this yourself, you can go back to, like I said, go to Google, type in American Federation of Teachers versus the Department of Education, and this is where you'll be able to see all of this documentation. But we'll see once the government shutdown is over, when these reports will be released, so that way we can kind of see where they are with these repayment plans and how much this shutdown has affected processing time. But at least thing that is good to know is that if you are someone who qualifies to have your student loans discharged in 2025, you're not liable to pay any taxes on it. You're not going to be hit with a tax bill come 2026 if that discharge isn't processed until that time. And also, if you are in a save plan and you transfer into another repayment plan, a qualifying plan like PAYE or ICR, and even income-based repayment, that your loans are qualified to be discharged, okay? But you have to get that transfer in by December 31st, 2025. Even if the application is still pending in 2026, as long as you have that dated application or that dated transfer on or before the 31st of December that you come out of the save plan, then you are good to go. All right, y'all, we'll stay connected and we'll see what's next. All right, good luck with everything.